All right, we'll go ahead and call this meeting of the Senate Ports and Marine Resources Committee to order. We've got one bill on the agenda. It's Senate Bill 2780. It includes revisions to the Public Trust Tidelands code sections, the Secretary of State code sections, as well as the Gaming Control Act and the criminal penalty sections of our code. I just want to start off by saying the purpose for this bill was brought into contrast late last year. There was a gaming commission decision approving a site, and that decision came on the heels of a Supreme Court decision that pointed out some ambiguities in both the Public Trust Tidelands Act as well as some inconsistencies between the Tidelands Act and the Gaming Control Act. The purpose of this bill and why it's got so many code sections open is to provide some clarity for the court and for us as legislators of what the Public Trust Tidelands Act actually means, particularly in the context of the Gaming Control Act, and to provide some consistency and stability for our gaming operators on the coast, as well as our municipalities on the coast that are affected by Public Trust Tidelands, which is a component of the bill that we've worked very hard on between Senator Blunt and I, who's chair of gaming, as well as with the Secretary of State's office and our folks back at home. So just to go through the bill section by section before we get to questions. The first, section 1, that deals with duties and powers of the Secretary of State and clarifies that the Public Trust Tidelands are part of the Secretary's responsibility. Section 2 opens up the Public Trust Tidelands Act, and the main thrust of those revisions start on line 98 and run through line 108 and clarify that anyone wishing to apply for a gaming license is required to have a lease from the Secretary of State for the lease of the Public Trust Tidelands that will be used for that license application. Same on lines 148 to 155 and lines 166 through 180. And again, at lines 215 through 221 deal with our in lieu assessments. The in lieu assessments were something that came into being after Hurricane Katrina on August 29, 2005, when the casinos were allowed to move north of Highway 90. And it clarifies there that the gaming site must have a lease from the Secretary of State for that site. Turning to lines 283, that's the beginning of section 3. That's the definition section of the Public Trust Tidelands Act. And it clarifies both the references to the department and some other definitions that are used later throughout this section. Section 4, starting on lines 329, is the legislative public policy section. And there it spells out what we're trying to do. This will clarify some of the ambiguity that the court has been able to reference in recent decisions to clarify that it's the legislature's intent that Public Trust Tidelands can be used for gaming, provided they have a lease from the Secretary of State. Section 5, starting on lines 357, is more of the Public Trust Tidelands Act, and on lines 173 through 380 or 373 to 384, you'll see that the administrative control and authority of the Public Trust Tidelands rests with the Secretary of State, and that the state maintains fee simple title to those tidelands. Section 6, starting on line 385, involves the lease provisions, and this is the first section that is of most concern to our municipalities back at home who have harbors. Um, Starting on line 406, section 4, or subpart 4, provides that all the proposed public uses by any state or local governmental entity of Public Trust Islands must serve a higher public purpose. And you can read that for yourself there on lines 408 to 414 of what that higher purpose would be. And then from a friend from Hinds County, he summarized it, anything involving water, which I thought was quite succinct and accurate. In lines 415 through 420, that's the crux of the bill for me, and I think for this committee and our concerns, is making sure that our local governmental authorities maintain exclusive control of the leased property. So for those of you who may not know, for example, the city of Bay St. Louis or city of Pass Christian, they have a municipal harbor that is on public trust islands that's under lease from the Secretary of State. Once they've got their lease in place, anything that the municipality does inside the harbor, so long as it conforms with that higher public purpose as defined, they have exclusive control over the premises. Subpart 6, rather, on the starting line 421 through 424, to comport with the earlier provisions of the Public Trust Islands Act, clarifies that they can't do anything. The locals cannot lease or sublease out those tideland properties that they have under lease from the Secretary of State for any gaming or gaming-related purpose. Section 7, starting on line 425, brings forward the Public Trust Tideland Fund language to make sure to basically conform with some requests from the Department of Marine Resources and with some requests from the Secretary of State office. It's just clarifying language there. Section 8, starting on line 462, is the conforming language regarding the Public Trust Tideland Fund. Section 9, starting on line 506, is the lease language where entities can lease Public Trust Islands land from the Secretary of State. And again, we've incorporated that higher public purpose language from earlier and added some additional language there to make sure that it was anything to do with water. Subpart 2, starting line 517 through line 520, clarifies that no lessee of Public Trust Tidelands can sublease or rent out that leased property for gaming or gaming-related purposes. Section 10, starting on line 521, brings forward the Harbors Act. Additional language or clarification language there starts on line 544 through 556. And in that language, we clarify that so long as that long as that municipal authority is operating its harbor within the existing language or within the existing authorizing language of that section, so long as that harbor or municipal authority or harbor authority is operating that harbor consistent with that language, that they have exclusive control of the leased premises and all revenues generated therefrom to maintain and repair and improve the leased property. And again, the same that we've gone over on lines 597 to 599, we create a new subpart 7 that prevents the municipal authority or harbor commission from leasing that property for a gaming purpose or a gaming operation. Section 11, starting on line 600, Municipal Harbors Act. Again, starting on line 616, we clarify that provided that the local authority is operating that harbor within the original intent of the original language, that local authority has exclusive control of the leased premises and all revenues generated therefrom. Then begin on line 625, we clarify that the municipal authority cannot use the lease property for any gaming purpose. And Section 12, starting on line 632, brings forward the Gaming Control Act. Starting on line 679 through 704, codifies existing and longstanding gaming commission regulations as far as what could make a site suitable for a gaming operation. And I'll note for this committee that on line 700 through 702, the Gaming Commission can deviate from these minimum requirements for any proposed project or proposed gaming site along the Mississippi River. So these regulations that are being codified here are really more for the coastal counties. Section 13, starting on line 736, brings forward the code provisions for contracts for gaming and future wagers. You'll see a reference on line 763 to August 29, 2005. That's the date of Hurricane Katrina. For members of this committee, before Hurricane Katrina, we had casinos that were floating, that were located just off the beach. Some of those got destroyed in the storm. After Katrina, there was a special session held, and there were revisions made to the Gaming Control Act and other provisions to allow those casinos to move on shore. And again, in lines 774 on downwards, we are clarifying and codifying what qualifies as a suitable site. Section 14, starting on line 810, is the crimes code sections, and that same language that you see in section 13 is incorporated throughout the remainder of the same language regarding site suitability is incorporated throughout the remainder of the crimes section of the bill. So that's an explanation of the bill, and I'm happy to entertain any questions the committee may have. I'll also note that we've got representatives from the Secretary of State office who may be able to provide better answers than I can. And I don't see anyone here from the department, but the Secretary of State office is here. So, any questions from the committee on the bill? Senator Seymour.
Mr. Chairman.
Yes, sir.
The mean high tide is the line that we're going to go by from here on out. Is that, you're establishing that with the DMR and all?
Well, I'm not sure what you mean with DMR, but in the public trust tideline section, we are clarifying where that public trust tideline start. So it's the mean high tide line, but you've got sections. If you look with me on again, in section 3, it's the definition section, begin on line 283. They created a definition for fast lands, which means tidelands and submerged lands waterward of the historic mean high tide line that have been filled, and it moves the mean high water line back to where it would have been before it was filled.
Thank you, Mr. Chairman.
Any other questions from the committee? Seeing none.
Whoa. You know I have questions, but I was letting everyone else ask. Mr. Chairman, I said this in the gaming before, but for those that are just joining us into this committee, I want to thank you. I want to thank you for everything you've done. You've put a lot of effort into this. I also want to thank the Secretary of State himself. Back in 2010, I believe it was 2010, 2011, he worked with me while I was in the House. He was a senator at the time to try to address some of these issues. This is a very complex issue that affects all of our communities along the coast. we've been unsuccessful in trying to get a meaningful piece of legislation passed. A lot of it has had to do with the fact that there's been ongoing court cases for 10 or 15 years now. This is one of the first times that we have not had a court case pending with respect to tidelands or definitions or any of the interpretations of these laws. So you've done a yeoman's work on this, and I know that you've worked tirelessly with communities on the coast to make sure that we get this right. And this is the first bite of the proverbial apple that we've had to change this, and I think you've done a great job. That being said, first of all, Chairman Briggs had asked me to make sure that none of the changes in this bill will affect any of the rivers or other state waters that are north of the saltwater areas, as we call it, along the Gulf Coast. Is that correct?
That's correct. And the changes to the and the codifying of the Gaming Commission regulations, the river communities are expressly excluded from having to comply with that. The Gaming Commission can deviate from those regs.
That's correct. Great. I appreciate you saying that. I know he'll definitely want that. So you've got a lot of changes that have affected what we've, for a very long period of time, we've tried to make sure that the municipalities that have the small craft harbors and marinas have autonomous control of those structures and those facilities. And there has been some difficulties over the years where the Secretary of State has exerted some authorizing control and or has had some required inputs for any changes of zoning. Is it the intent of your bill and the intent of the Secretary of State as you perceive it to make sure that the legislation here states very clearly that if the city is granted a no-cost tidelands lease and there is a small craft harbor area as denoted to currently or anything that future that is designed in comports with these particular laws, that the municipalities will have ultimate control and decision-making processes for all aspects of authorized activities within here, except for gaming. Is that it? So,
It's on lines, well, it's throughout the bill, but on line 415 through 420, that's the exclusive control of the leased premises, provided that the leased property is serving that higher public purpose. That's defined in line 406 through 414.
okay. And as you know, I think it's a jurisdiction that I represent, the city of Biloxi. If I'm not mistaken, I do not believe that they have a tidelands lease they have not executed a tidelands lease in the past for their small craft harbors or any of their municipal harbor areas. And if I'm not mistaken, the city of Gulfport has some kind of a settlement agreement that was worked out with the Secretary of State, not necessarily a lease, but it is a document that kind of serves similar function, right? Will those entities be required to execute a no-cost lease to comport with the proposed amendments in this bill?
Well, you brought up two different scenarios there. If a municipality has a harbor that doesn't have a lease, this would require them to get a lease from the Secretary of State at no cost to operate that harbor, consistent with what you think of a normal harbor operating. That lease would not allow that municipality to use that lease for a gaming operation or provide nexus for a gaming operation.
Correct. Okay.
The second scenario you brought up was the city of Gulfport, rather, and its use agreement, I believe, is what's titled with the Secretary of State. This should not have any effect on that. Their use agreement is, and I understand from the Secretary of State's office, that use agreement is for all intents and purposes a lease. So this would not affect that.
So there's no action that would need to be taken by the city of Gulfport to continue their operations of their small craft harbor?
That's not the intent of this bill.
Okay. Now, when we go back to the bigger picture is there are entities that have already executed a no-cost lease with the Secretary of State for the use of their small craft harbors areas. It's been a number of years since I've seen that actual form of a lease. But somebody forwarded it to me the other day, and the form that I had was from 2016. In that particular lease form, other than the fact that it was zero cost or consideration, money consideration for that, there were quite a few other sections to that lease that had some restrictions, very similar to what I would see in a commercial lease, where it was easements, covenants, and restrictions from different types of use. And then it also required written consent from the Secretary of State for certain things. And that has come up in the past where the city of Biloxi has tried to change the zoning classification for a piece of Tidelands property from, I think it was from a gaming operation to a commercial operation. And there was some, I can't remember who the Secretary of State was at the time. But anyway, there was a little bit of a rub there. Those leases that cause a lot of problems. I want to make sure that as we go forward, that the Secretary of State's office is either required to file or to do amendments to the existing lease, the leases that are in place. But I want to make sure that there is no municipality on the coast that will have to come to the Secretary of State's office to do anything that is authorized and spelled out specifically in the Small Craft Harbors Act. Is that the intent of what we're trying to do here? And will that require the Secretary of State to do a lease amendment for those municipalities?
The intent of this is to preserve and to clarify that local control over their harbors. That so long as the harbor is being operated consistent with the purposes outlined both in the Public Trust Islands Act and the Municipal Harbors Act, that they do not have to come back to the Secretary of State for any kind of permission to say, build another dock, add an ice house, somebody wants to bring in a bait camp or something. That use, so long as it's consistent with what's in here, they will not need to come back to the Secretary.
So they won't need to come back to Jackson and ask for permission for something that they are paying for in our local harbors, that they are responsible for the maintenance of, or any of those, and they collect those revenues and they keep those revenues for that purpose, correct?
For the purpose of making repairs, modifications, or improvements inside the harbor.
Okay, this is a very complex bill and a very deep bill, and I'm sure I'll have other questions, but thank you very much. I appreciate your time.
Thanks, sir. Is there anyone?
For a motion at the proper time.
Any other questions from the committee?
My motion will be title sufficient to pass.
Got adopted.
My motion before that is to adopt the committee sub.
Heard the motion, all in favor?
Aye.
Opposed? All right.
Seeing that we've adopted the committee sub, my motion is now title sufficient to pass committee sub.
Heard the motion, all those in favor?
Aye.
Opposed? Motion carries. Next one. Need one more. There it is.